footage last night was all of everybody waiting on the steps of the Supreme Court for the Nixon ruling, and Watergate prosecutor Jill Wine-Banks is here with us today on this historic Supreme Court day. Jill, thanks so much for taking time. I know you're monitoring what's going on and crazy busy. But so talk about, we just started talking and then I hushed you. I was like, just save it. Because because just your initial impressions are what we're hearing, that Sotomayor is asking very pointed questions. Gorsuch looks like he's in play. Tell us your impressions so far.
You've got two of them. Justice Breyer is equally in the mix here. And Thomas has once again asked one of his rare questions. He has spoken. Usually he doesn't. But Sotomayor has been very, very clear in her questions and very clear, I would say, in demanding an answer to her question, not to what the lawyers wanted to say, regardless of what she asked. So she's been, I think, very clear, and so has Justice Breyer. The whole thing does bring back memories of being being inside the court during the Nixon arguments. And of course, those are being referred to in this case, as is Whitewater, as is Paula Jones. And so far, I have to admit, I start with a bias based on what I believe the Supreme Court will do, should do, can do, what's consistent with their prior practices. So I start with the Nixon case and saying that the president is not the king, the president is not above the law, and that he cannot stop his accountants from turning over the documents that are in their possession that have nothing to do with, there's no privilege claim because he wasn't president. These are pre-presidential.
Well, but also, isn't that the key difference with Nixon, Jill, that everybody's talking about? The subpoena is not to him. It's to these financial institutions, right? Isn't that a key?
Yeah, that makes a difference in terms of whether it's a burden on him that could interfere with the conduct of the office of the president. And it can't, because he doesn't have to do a thing in regards to this. Right. And to the extent that he would have to, you'd have to look at the Paula Jones case and the court saying, yes, we could make accommodations to suit his timing, but he has to respond. And if you can be forced to respond in a civil case, then there is no reason why you don't have to respond. Right now, they're arguing about Congress's power. There is also the New York District Attorney's case will be coming up after this one, and that raises a different set of issues. But this has to do with legislative oversight.
Lawrence Tribe just tweeted, he's watching as well, and he said, Trump's lawyer says Whitewater and Watergate were, quote, too recent to count as precedent for demanding information from a sitting president.
Wow, I missed that. That must have been while we were talking.
I think so, yeah.
Whoa, too recent to be precedent.
Right.
Okay, that is a novel, I hate to use the word novel in terms of virus, but that is a novel argument. It certainly is an unprecedented one.
Yeah. This ain't Jill Wine-Banks' first time at the rodeo. It's hard to shock Jill Wine-Banks.
That is shocking. That's shocking.
And I imagine, did he say what the court's response to that was?
No, he hasn't said.
Well, Jill, you said it best. You said, can we trust SCOTUS to save us from Trump? I mean, today's the day we're going to find out. Is there still justice in America? Is one man above the law? I mean, for those of you who just tuned in, so just what is happening, in case you don't know, Trump is asking the Supreme Court to grant him sweeping immunity from investigation by Congress and local prosecutors into his conduct as a private citizen. They'll explore Trump's claim he cannot be subjected to subpoenas or any criminal investigative process by virtue of demands of the presidency. He's, as you know, Jill, been completely unsuccessful at every level up until now. It would literally put the president above the law if the Supreme Court sides with the president's lawyers in this case, said one legal expert. So that's really what we're deciding: is, are we a nation of laws today still, or are we are we a nation of men? Right? It
would totally obliterate any oversight if he had his way. If Trump had his way in this case, how could Congress do any oversight? How could they investigate children in cages? How could they investigate the misspending of any money? If he were totally immune from any subpoena, that's an absurd concept. Limited immunity is recognized. That's Nixon case, recognized for the first time in that there is such a thing, but it doesn't grant the kind of sweeping powers that say, I and I alone can decide what is going on here. No one can investigate me. Can't investigate him? That's even beyond the Office of Legal Counsel that says you can't prosecute him.
I mean, his lawyer literally did use the Fifth Avenue argument, right? I don't even remember which case that was in, where he said, yes, the president can shoot someone on Fifth Avenue. Not only can no one stop him, no one can charge him, no one can investigate him, no one can indict him until he's out of office. I mean, it's so absurd. You don't even have to be a lawyer, right, to go, wait, what?
I think letting Americans hear these arguments live, and I was live streaming it before we went on, and I'm recording it now so I can listen to the whole thing, really will make a difference, because hearing the president argue in the Supreme Court that he is above the law is something that should frighten even his most ardent supporters. You may believe in all the policies that he wants to enact. You may not mind his crudeness in office, his lack of a decent vocabulary. You may find those to be charming and endearing and make him seem real. That's all fine. But there has to be someone else who can carry out his policies without violating the law and obliterating all of the institutions of government. The same thing is true in the Flynn case. He's really arguing in Flynn that he's above it all, and that what he's really doing is trying to obliterate the entire Mueller investigation, the Mueller report, the Department of Justice, the FBI, and William Barr is a willing enabler of him in that case. So these are both sort of the same thing, both what's happening in the Supreme Court today and what he's doing with Flynn.
You tweeted about that, outrageous. You said this would be like Nixon dismissing Watergate special prosecutor case after our office had finished its work and closed down. And you said cronyism isn't the reason, corruption and cover-up are. 45 wants to dismantle everything Mueller did. And well, as you know, 2,000 DOJ alumni call on Barr to resign. I mean, obviously no real prosecutor would even sign this, right? Who wrote the op-ed? The guy that quit over the Stone case that said, here it is again.
Yes.
This is...
And by the way, so did Miss McCord, who was relied upon dramatically in saying, this is why we should dismiss it. There's really no cause. And she wrote saying, I am totally misrepresented in what I said. It's taken out of context. It's not what I said. Nothing I said justifies dismissing this case. And I believe that Judge Sullivan is now, as the Supreme Court is this morning, is in a very pivotal place to help save democracy. He can refuse to dismiss it. He can refuse to dismiss it he can say it's only dismissed without prejudice, which means that it could be refiled by a legitimate prosecutor in the future, assuming the statute of limitations doesn't run. And since this particular crime occurred very early in the administration, it's going to be very, very timely as to whether it can be brought before a statute runs. So I think we're in a really serious point of view, but I think Judge Sullivan needs to really have a hearing on what the claims are. And of course, McCord would be a witness. Interesting that the name is McCord, because the real whistleblower in Watergate was McCord.
I know. You know why I know that? Because I read Watergate Girl, which is the best book in the world. Okay.
Thank you.
I was saying, even your decor is classy and beautiful and fantastic, just like you. Look at the artwork, look at the sculpture, look at the Watergate Girl. She has a book right there, of course. It's fantastic. But you also you talked about the long list of people who thought Flynn's lies were material. Of course they were. But you said Judge Sullivan should reject the dismissal as baseless in an attempt to cover up crimes at the White House. That's the legal point. Is it's clearly an attempt to cover up crimes, which is why he should dismiss this. Judge Sullivan talking about,
if you read the motion to dismiss, the legal arguments and the factual arguments don't pass the red-face test.
Right.
It would be impossible for me to stand before a court and argue what they've argued without bursting into laughter or blushing. It would be just absurd. They don't make any sense. And I believe that hopefully Judge Sullivan will have the time to look at this and think about it and decide how to handle this appropriately. Judges can refuse a plea agreement. Judges can refuse a dismissal. And they only can allow a dismissal where it serves the public interest. So we need to look at that. There was a case in Watergate where there was an argument over dismissing a case in Texas so that the defendant in that case could plead guilty in D.C. and testify against Governor Connally. And the public interest in that case clearly warranted dismissing the Texas case to allow the case to proceed in D.C. This is a case where it would disappear completely. It's not, he would be prosecuted somewhere else, and it doesn't address all of the other crimes that he got off of before, as part of his plea agreement. Yeah. He wasn't charged with other things. So will those charges be brought then?
Yeah, exactly. We shall see when President Joe Biden appoints Attorney General Jill Wine-Banks. Okay, quickly back to the Supreme Court. Neil Katyal said, Supreme Court, they're probably pretty happy with the lower court reasoning in these cases. As we know, the lower courts have upheld, the subpoenas as serving legitimate purposes. I don't understand. The law says shall furnish his taxes. It does not say maybe or whatever, even just that part in terms of the congressional requests. And then Paul Clement said, I think if you look at the court's precedents, the president's argument is a tough one. Jill, is the key, as I'm hearing, as we mentioned a little when we started this interview, is the key the fact that because the subpoena was to Nixon and to turn over the tapes, which he did, a lot of people were saying if the subpoena was to Trump, we know what would happen. He would refuse it and then we'd be in a constitutional crisis. But this is not to him, and all signs are is the Deutsche Bank or whoever would comply. Am I wrong?
And Mazars.
Yeah, Am I wrong?
No, you're quite right that they would definitely comply. They have shown no inclination. And by the way, while we're talking about...
But isn't that why he's freaking out? Because if they rule against him today, there's nothing he can do about this. His taxes and financial information are going to be released, right?
That's maybe why he's freaking out, but he freaks out almost every day.
Yeah.
Think about him walking out of a press conference because two women asked him questions. But I want to go back to the Supreme Court argument today because I heard only very briefly before we got on air that the lawyer for Congress was testifying, that was arguing, and he pointed out how wrong the other side had been and had misquoted them and pointed the court to the right pages that did specify why they needed this and why they had a legitimate legislative purpose. So you always have to hear both sides. The hard part was we had to get through listening to the president's, the government's lawyer and the president's lawyers arguing, but now the court will have it put in context by being able to hear the other side of the argument.
Okay.
I also think that this should lead to people being able to hear on a routine basis Supreme Court arguments. It's not interfering with anything, and it's really interesting to be able to sit and listen as it's happening.
I mean, it's too bad, right? The pandemic, that we can't all be sitting on the Supreme Court steps like those people were. I was so hoping someone was going to go, oh my God, Jill Wine-Banks is so smart and also so pretty. I'm just waiting to watch her walk in. Okay. Well,
that was my first time sitting, in the Supreme Court. I was admitted that day to practice before the Supreme Court, so it was special, not just because of the case, but and then I later, when I was Solicitor General of Illinois, got to argue in the Supreme Court, and it is an awesome experience.
I bet. So listen, after all these female reporters stood up the president yesterday, you've got to read Watergate Girl, about a woman before her time standing up to the big boys back in the Watergate era. It's so fantastic, Jill. Always so proud of you, so privileged to know you.
Thank you. My pleasure, I am sure.
And she's doing an event for Joe Biden. How do we find out about that?
Yes, it's Students for Joe Biden. And I tweeted it, but I'll tweet it again so that if anybody wants to join in, they can hear. It's sponsored by a wonderful student. I think the youngest person ever elected as a delegate. He's graduating high school in a few weeks. I predict that Victor will have a very long and successful career in politics. He's planning to start school in California.
All right.
In the fall.
All right, I'll take it from here. I'll be part of the village
Yeah.
that raises him. I'll take
You
it
have
from
to mentor
here.
him.
All right.
Have him on air. He's terrific. I will send you his contact
All right.
information.
Awesome.
Follow
He's
Jill
wonderful.
on Twitter. Buy her book. Worship her like we do.
Please do.
Talk to you soon, Jill. Thanks so much.
Thank you so much. It was a pleasure.
Thanks,
Bye, honey.
Jill.
Love you.
Bye.